Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listener. This is number 16 in our series of Unpacking Contract Law podcasts. Just to say, I am joined as ever by the lovely Dr. Severine Saintier. I've mangled the French, but you know who she is. And Dr. Tim Dodsworth, and this is me, Maggie Hemsworth. And in this one, we're going to talk about Blu-Sky Solutions and Be Caring Limited. And this is a High Court decision in 2021. And before we get going, thanks as ever, or at least recently, heartfelt thanks to Newcastle Law School, who are kindly supporting us with all the tech and the difficulties and the expense of editing and so forth. So we are very grateful, as ever, to Newcastle Law School for their support. And we'll mention them again later on. But to get going now with this case, as I say, this is a High Court decision in 2021. And I suppose the label to this podcast might be the power of the signature, ? And that's really what we're going to be discussing, I think, as things go on. But who knows? That's my guess. That's what we'll be arguing about, discussing. So a bit of the brief facts, just so that, dear listener, you are on the same page as us, more or less. So Blu-Sky were the claimants, and they were suppliers of mobile phones and services. And they were seeking to recover a cancellation fee from the defendants, Be Caring Limited, and like its title suggests, these are providers of social care. And the contract was for the provision of 800 mobile phones over a 48-month period at a cost of £9,600 per month. Now, the basis of the claim was on an order form which had been signed by an officer of the defendant purchaser. And the order form did not itself contain the clause which enabled the claimant to seek this cancellation fee, but rather that was referred to and appeared in their standard terms of trading, and those trading terms were available with some difficulty, but they were available on their website. Now, the cancellation charge was an admin fee, or at least expressed as an admin fee, of £225 per phone, and that came to a grand total of £180,000. So rather eye-watering, I imagine, for the social care provider. And they had denied that the order form was a contract. They thought it was just a preliminary step. But the court, I think, was quite easily found that actually on an objective assessment, this was recognised as the contract itself. Nothing had been done to draw their attention to this term, which looked pretty onerous at £225 per phone admin fee. But the court decided that the claimant had done enough to refer generally to their terms and conditions on the website. But the key question was whether more had to be done in relation to this particular allegedly onerous clause. And so I suppose this is a sort of a tension, as it were, between that old case, or relatively old case, 1934, Lestrange and Graucob, as to the power of the signature. Listener, you might remember that Tim is particularly keen on the power of the signature. I think you said before how forceful this is. And so really this is the $6 million question, as it were, in this case, whether anything particular has to be done to draw a signing party's attention to this sort of clause, or whether the signature is sufficient of itself. And that 1934 case, Lestrange and Graucob, probably supports the claimant in this case in saying, well, the signature is there, whether you read it or not, whether you bother to do anything other than write your name at the bottom, so be it, on your head, as it were, be it, and you are bound by the terms, other than possibly in the extreme situation of fraud, or in later cases, we've had the idea of misrepresentation creeping in. And I think there's some other cases that suggest maybe, possibly, pressure of time and so forth. But we don't have, I don't think, a lot of clear law on that front. Or whether it is the case that some specific attention has to be drawn to this onerous clause. In other words, lawyers out there might know the case Interphoto, Lord Bingham, who created this idea of drawing attention to a particularly onerous, exorbitant, extreme, I think all of those words tend to be used, whether more has to be done. But in the Interphoto case, the term wasn't in a signed contract. It was referred to in a document, but none of the documents were signed as such. So we've got a possible tension between, as I said at the beginning, the power of the signature and this idea of drawing someone's attention to onerous terms. Does that apply when you've signed the thing? So there, I throw it out now to Dr. Saintier and Dr. Dodsworth. Do you think the High Court here got it right? Because they were saying, really, I think, that you have to read these two things together. And I suppose what they're saying is, even though the document is signed, there may be some instances when you still have to do more than simply say, there's the signature, end of story. And I suppose there are cases that talk about terms being, quotes, buried in the thicket. It's a phrase that judges have begun to use. So very small print that might appear on page 900, say, of a 1,000-page document. Well, I'm offering that as an extreme example, maybe. But I think the High Court is saying that we can't have a false binary, I think is the phrase that they use, between a document that's signed and a document that's not signed. The signature will be powerful, in many instances very powerful, and I suppose if the term is relatively clear to see, not complicated, not buried in a thicket, then probably the signature will be end of story. But it may not be that where it's hidden in a sense, not necessarily fraudulently, not necessarily intentionally. Nevertheless, it makes it very difficult for the signing party to really understand that there is this term, whether they've bothered to read it or not. And that sort of reasoning assisted the defendant here, B. Caring, to avoid having to pay this £180,000. In other words, the claimant was not successful. And it's perhaps an open question whether a penalty argument would also alternatively have succeeded. So there it is in outline. So Drs. Saintier and Dodsworth, did the High Court get this one right, or are you troubled by it? What do you reckon?
I think it got it right, but there are some elements which are not entirely clear. So I think it got it right. And I think here Judge Davies clearly had sympathy with the defendant, as you said, Maggie.
Sympathy won't cut it, though, will it,
Well,
Severine?
no, but I think there are some, they drew attention to the fact that it was a care provider. They drew attention to the fact that the CEO of the care provider drew attention to, my God, £180,000, this is going to be a big gap to our budget. And so Judge Davies said, I do have sympathy, but ultimately, looking at it objectively, that should not make any difference. And yet, on several occasions, at some point, they do say, so even though it is a business-to-business contract, an objective assessment, etc., they seem to have, again, sympathy to the defendant. I mean, they did, Judge Davies did say that at paragraph 112, that what the claimant did was close to misrep. That's quite a powerful thing to say. So I think they got it right, because it is true that, I like what the distinction has been drawn by Judge Davies. Or just because a term is standard and well known, and it's therefore not unusual, doesn't mean it's not onerous. So I think overall it got it right, but I am not entirely sure about what they say on the first question. Does the order form have contractual does the order form create legal relation? So Judge Davies draws.
Yes, I think they concluded it did, because you apply the objective approach, RTS flexible systems, that one. You stand back from what the party thought themselves.
Yes.
So the signing party didn't think it was a contract, but that's not really the question. The question is, standing back from either of those parties, would an observer conclude that was the moment when the deal was struck?
Yes.
And the answer was yes.
Yes. So I think it got it right, but it probably would have been quicker to just talk about incorporation. So yes, I think it got it right. Clearly, the sympathy won. I think it got it right.
You sound slightly hesitant, unsure about them getting it right, though. What were you uneasy about?
So I didn't quite. So at paragraph 86, when they draw the analogy with an intermediary, I didn't quite understand why they needed to do that, but no, I am firmly of the belief that they got it right. The clause was onerous, and I think it provides a good clarification on something that you mentioned, Maggie, about the distinction between when there is a signed contract and when there is not a signed contract, and the terms are simply referred to in another
but they seem to go even a little bit further than that, don't they? Because they seem to be saying, yes, there is a distinction between terms that appear in the document that you sign and terms that are merely referred to in the document. And I suppose a contract, thirdly, where nobody signs anything.
Yes.
But they're in the documents. But I think they were going further still. Although I suppose strictly that's obiter, is it not? If the term had appeared in the order form, as it were, the thing that was signed, so it was in that document rather than merely referred to in that document, that in itself would not in all cases mean necessarily that the signature, if you like, trumps everything else. There might still be occasions when you would have to do more than present the thing for signing. So that a little bit more than we've had, I think, in the past. And of course this is only, I say only, I don't mean it disparagingly, but this is High Court rather than Court of Appeal or Supreme Court. So we can't actually say, that this is guaranteed to be now the law, as it were. In terms of precedent, it doesn't carry the necessary weight, does it? But I agree with you. I think they're right. I mean, is Tim going to now argue?
No, but there was In terms of precedent.
Absolutely. Wrong.
You like Lestrange and Graucob, do you not?
Well, so, I mean, the first...
I know.
Hard cases make bad law, right? That's what we're looking at here. I can see how the judges have a nice, warm, fuzzy feeling looking at how they're helping care provider.
That's not fair. Not fair. That's not what happened.
Well, so, I mean, there's two distinct cases here, I think, that we need to... where I can see a certain gap, potentially. But I think we need to look at why, or what the signature is actually meant to be doing. The two type of cases that we have, if we have a document that somebody signs, like in Lestrange, and all the terms are contained within there, that would be number one. And number two, here we have the terms and conditions that are implied by, that are incorporated by reference, but the contract is actually incorporated by signature. So, there is a distinction, I think, between those cases, and it does open up a certain door potentially. And I think the case that we might want to consider there is Ocean Chemical Transport and Exnor, where the court did actually draw a distinction and particularly said, if we have certain circumstances where pressure is applied, where there's not much time, then we might be able to look beyond. And the reasoning behind that is why I think we originally, or what the signature is meant to be doing. The signature is creating the certainty that we need, particularly in business-to-business contracts, that the other party has the autonomy to either read the cases or give up that right of reading the terms and conditions, or giving up that right. We have the option whenever we sign something. We have the autonomy as individuals to say, I just don't want to read the terms and conditions. Now, what we're doing really in this case is saying, well, we want to apply the same standard here as we do to consumer contracts, right? We want the terms to be transparent and not onerous and clear, and they should have told them beforehand.
No, that's
and this is, I'm going to hark back a little bit.
No one's talking about
really,
consumer legislation in this.
Well, because they can't.
No, but we're not trying to apply it by analogy.
But these are two businesses. These are two business. Well, okay. So the reason I'm mentioning that is because, of course, if we look back at the good old days of the Unfair Contract Terms Act applying to consumer contracts, we might have been able to make an argument here that this was outside of their usual business. In other words, they may well have fallen beyond within that standard. So that would have been a way that we could have cleared it up some time ago, right? What we can see from the way the care provider here is acting is that they had no clue how this whole process worked. This is really the case that they're trying to make, is that we had no clue. We don't usually buy mobile phone contracts. This is not our business. We care for people. We don't go out buying mobile phone contracts. We had no clue what they were doing.
What about the point that the provider failed to comply with the code of conduct, code of practice for sales of marketing mobile phones? So that's nothing to do with the consumer, but it's mentioned in the judgments that the process by which they were signing this business into this contract did not actually comply with a code of practice. I mean, is that meeting the reasonable expectations of business people, to misquote Lord Steyn?
Wow, we've come quite away from the original point, but
no, we haven't, because it's your point about a document which is signed needs to have the degree of certainty and predictability that comes with the signature, and in principle, I don't have any difficulty with that, and I'm sure Severine doesn't have any difficulty with that. But if you take what you're saying to the logical conclusion, it would enable one party to create a very long, complex document and present it for signature. And so long as they don't put them immediately on the spot, sign it now, a 900-page document, you're saying then there is nothing that one can say or challenge in terms of incorporation. But I'm using the language of Lord Steyn now. Is that the reasonable expectations of business people? So it's not looking to challenge the clause the term in terms of unfairness. That's the Unfair Contract Terms Act. We're not talking about that at all. We're talking about purely that first question as to whether it's part of the deal at all. So just in that procedural sense, is it what reasonable business people would expect the law to be saying?
Well, the question is, would it be reasonable to expect that someone who's presenting you with a 900-page document might be hiding something in the terms and conditions? You would expect that. We're a hard-nosed business. There's no requirement of good faith, as Maggie, I think you've said a number of times, in English law. Up until the signing of the contract, we are hard-nosed negotiators.
Well, what I've said before is that English law has no general overarching principle of good faith, but what we have said previously is, yes, but English law is very good at responding to what I would call bad faith in a piecemeal, isolated way. And that is the surgical approach which the common law takes, quite different from civil codes on the continent. But we end up possibly in the same position by different means. Length. So I would say that the incorporation procedural stage does have inbuilt into it some sort of implicit good faith going on, if we don't balk at the use of the phrase. It's the English way of doing things, that the process itself should be a reasonable one, and that's a very generalised statement. And what we're talking about now is the specific instance of what we mean by that. So fair notice of unusual, extreme, excessive clauses, for example. I'm not talking about penalties yet, because that's probably a step even beyond that. Do you know what I mean? Exorbitant, not legitimate in any shape or form commercially. What you're seeking is to punish and frighten. That's probably even more than the sort of terms that we're talking about now. So we're not engaging penalty law, but we are engaging, I think, and that's the way the High Court's approaching it, the process of incorporation. And so, all I think we are arguing about at the moment, Tim, is how much weight the signature should carry. And I think you probably want it clearer as carrying a weight in all but the extreme circumstance. Question what that means. But for the interests of certainty and clarity, I think you would give, if I understand you correctly, the signature that degree of significance that you think it justifies. So if you like, I think probably the three of us at the minute, if I sort of try and put words into Severine's mouth, I think she and I are closer to the idea of a sort of spectrum of possibility, and it being very fact sensitive. And, we never say never, as it were. Generally, I think that's true for the common law. You never say never. There might be some instances when the signature isn't enough. And I offered the example of a very long document.
I don't think that's even what they're saying here, though. I think that's taking it another step further. What we're talking about here is if the terms had been in the document, I don't think they would have had a ground to make the decision they made. The decision here has been made because they're trying to also incorporate the terms from the website. So we've got an incorporation by reference and incorporation by signature. So the actual document was signed and...
Yes, okay, but strictly speaking, it was obiter. So High Court and obiter, not ratio. But I think they were saying, the judge was saying, and in any event, it was at that bit of the judgment, in any event, there would be a false binary, I think that's the phrase that the judge uses, between a document which is signed and includes this term and a document that is signed but the term is on the website. That's, he's saying this is just a false, it looks like it's a different thing, but how different is it, I suppose, is what he's saying. And in many instances, not any difference. But I think he's trying to say it's fact sensitive. I think actually that phrase is used.
Yes, I think, we go back to the context and, in the manner in which it is done. I mean, so for me, the important thing is in a way, the protection of the reasonable expectation. So, Maggie, you did draw the attention to the code of conduct. For me, it's not so, so therefore to go back to the question that you asked, Tim, so is it a reasonable behavior by somebody to not, so can the defendant reasonably expect that the other party is going to procedurally respect the code of conduct? Yes. That is therefore a reasonable expectation, and therefore if they haven't, that, but for me I
think we could only say it's a factor, because remember,
I know,
it's
because so therefore
it's
here
code of practice, not law, but it would be something that a court would look at, I think, is what they're saying.
But therefore here, what it seems to me that the judge has paid a lot more attention is to the fact that, they did say that what the claimant did by not bringing sufficient attention to the defendant, to the content of that clause or those particular clause, what it would mean, what would be their liability should they not contract and all that. And then in the same, 2 paragraphs down, when they refer to this is close to misrepresentation and barring thing, this is for me the most important thing. So so you talked of spectrums. So perhaps what Tim was trying to say is that, so in relation to, when the UCTA applied also to business and consumers, it's not so much here that, it's not within their ordinary business to sign contract, because ultimately they are in an area where they will have to sign contract. But here it is not so much the fact that, so the defendant is not in the same position as the claimant is, because the claimant's standard terms and conditions are well known to them, and they are clearly trying to do everything in the standard form, which did contain, though, if you sign these, you adhere to our standard terms, etc., etc. They are trying to get one on them, for want of a better word. And so in that sense, they need to be, even though this is a B2B transaction, and objectively, nevertheless, the defendant, in a spectrum, since you mentioned it, they are not on an equal
I don't think that you could use that as part of your argument, though. If you were acting for the defendant here,
no, but because
we don't have this, we don't. So I don't know. French law possibly does, but you'll tell me in a minute. English law doesn't have this idea of unequal bargaining position.
No. But what I'm saying, we did talk about the reasonable expectation, and you did mention good faith.
Yes, but because, as you were saying, the judge says on the facts here, this comes close, but is not pleaded as such and not proven as such, misrepresentation. That's possibly telling us that it's quite a long way down the spectrum.
So I'm happy with an argument around misrepresentation. I think that's exactly where we are with the B2B philosophy in English contract law, which is, if so long as you don't misrepresent, caveat emptor, so long as you're not misrepresenting, so long you're not exerting pressure in the kind of duress sense, you don't have to say anything. And that applies, No,
but that's a separate parcel of law that might be engaged on the particular facts. It's just here they did not have enough to allege that. Obviously, they would have done in the alternative. They would have, just like they had a penalty argument as an alternative possible running argument, as it were. So you claim or you defend on whatever and as many grounds as you possibly can. It's just here they did not have enough for that sort of claim. But as Severine says, the judge actually notes that this is close to that, but not that.
But that also distinguishes. So again, that to me, that would have been, or that's an argument that I think English law is much better placed to take in comparison to removing the certainty that the signature would normally provide to B2B parties. Right? The limit for English law is you don't have to say anything, but if you do, you've got to make sure that there's no misrepresentation and you're not pressuring the other parties.
Well, that there is a worry, isn't there? There should be a worry, certainly for English law, that if we had a very stark, simple rule that says if a contract is signed, end of argument, we would have some creative people with expensive lawyers crafting long, complicated documents to bury things in the thicket. I use that phrase that the judges use. And would try and use this clarity and certain simple rule that you're advocating for, Tim, as a way of exercising bad faith. And if I use that phrase, English laws are happy with that. I think it's just this overarching sweeping statement, good faith. So it's an instance of sharp practice, I would say, and clever lawyering. And should we have a contract law that permits that to be so? And I think this case is along the road to sort of give a warning sign to the commercial practices that no, you can't rely on that sort of degree.
But we have to say that this case is the very first case
to shut out the policing.
But this is the first case that has ever gone so far. I don't think we see any other cases. I'm not aware of any other cases that have pushed the boundaries so far. So far, we have had just that rule. And so far, I am fairly sure that there are businesses out there that use just that practice. And that's why we always say in business-to-business contracts, you could have got legal advice. I mean, the general position, I think, in English law is you just should have known better. If you get a 900-page document that someone asks you to sign, then A, you should assume that is probably a contract, and B, you should probably get your lawyer to read it. And that has been the stance in English contract law right up until this case. I don't think there's any argument. I mean, even ocean chemical transport that says, there are exceptions to it, limits those exceptions so much. I mean, it's time pressure, is basically what they're saying. It would be the only real exception to that. So we have to acknowledge with this case is. So
are you saying this case is wrong then? That
yes.
it went too far?
Yes, I think that certainty is fundamentally important. Now, if we want to approach this, you were saying earlier on, we don't have this idea of unequal bargaining power and so on. Well, we do have that in in Schedule 2, which we get to by Section 11 of the Unfair Contract Terms Act, which will apply to those provisions when.
Yes, but that's on a different question, though, isn't it? This is the incorporation question, and what you're advocating, therefore, would place all the loads would have to be carried, as it were, by the Unfair Contract Terms Act.
Right, if we're talking about onerous and unusual terms, even Interphoto was really working towards, an unfair contract. It was a way. Well, the idea of incorporation back in the day was a way of dealing with unfair terms. Right, Thornton and Shoe Lane Parking. All of these kind of cases were all leading up to. Well, actually, what we need is an Unfair Contract Terms Act.
So you're advocating that there is now no need for the common law to concern itself. And all the load can be carried by the Unfair Contract Terms Act. The common law, get out of this argument as to.
Now you're misrepresenting my argument, aren't you?
Immediately.
That was a gross misrepresentation. That's
fraud. What you're saying. A 900-page document on your head, be it. You should get legal advice, and if you don't,
absolutely. In that circumstance, yes. I think in the case where the person signs the document. Now, I am willing to move on the fact that I do think so. One of the arguments the judge makes is there's no difference between the two cases I was mentioning earlier on. One being the reference to the terms on the website, and the other in the document. I think there is a difference. I think there actually is a difference between the two cases, and we have to accept that there is a difference. One is the document is right in front of you. You decided not to read it, whereas the reference to the website is a whole different thing.
It's not just incorporation; it's also the adequacy of notice, and interphoto is clear to me, even if the terms had been in the order form, would it have passed the adequacy of notice?
Absolutely, because you make the choice, right? When someone presents you with a document, says you've got to sign it, this is a contract, you make the choice. You can either read the document or you don't, and that the choice is given to you. That autonomy is given to you by the signature. The other person doesn't have to sit there, and that was part of the reasoning of having the rule, was that the other party doesn't have to sit there and say, right, let's read through every single term on this document. The whole point of having the signature was that you could give up that right of having to read it. You can skim it, you can do whatever. The other party doesn't have to take you through the terms and conditions. And then we found out that actually, okay, consumers do this habitually, and that therefore we need certain terms that need to be regulated, and the same applies for the Unfair Contract Terms Act that does the same. There's a good justification. But ultimately, if those don't kick in, if the terms are considered fair, and the other party has presented you with a document that you sign, that signature is evidence that you made the choice either to read it or not. And they made the choice here. They didn't read it. We have no evidence that they ever accessed the website.
No, I think it's made clear that they.
Yeah, but that's. I mean, a business who doesn't read the other person's terms and conditions. What were you expecting?
But it was accessible. Yes.
Yeah, and again, so then the argument. But that is a different point. So the judge could have found, okay, they were misrepresented.
Yeah, but they didn't access the website, remember, because they didn't think this was the contract. Yes,
which is a different legal ground.
But you are saying, you made a conscious choice not to read their terms. I'm just explaining why they hadn't. It wasn't because they had. Yes, all right,
no.
But
they thought it was
not that they made this choice not to read the terms and to sign and agree to the terms come what may. They did not think that they were entering into a contract. So there is an explanation for it, whether you like that explanation or not. But factually, it's not someone just turning their mind away from it willfully.
Quite. So but then that doesn't need to be solved by it being an onerous, unusual term. Right, that is a different issue. Right. So if we had asked them, had you known that this was a contract that you were signing, would you have read the terms and conditions? And they would have said, yes, of course we would. Well, in that case, the rule is working. Right. The problem was not that the terms were onerous and unusual. The problem was that they didn't know that was a contractual document. So the law doesn't have to fix.
That's a separate point.
That's what I'm saying.
But the problem in this case was the nature of the term.
The problem in this case was that they didn't read the terms and conditions because they thought it wasn't a contract. Really, at the heart of it, that's the problem.
That may be how it's come about factually, but legally, the point of the case is whether this term is unusual and excessive and oppressive, or to use the sort of language that Lord Bingham might have used. If it meets that sort of requirement, the question, and the only question really, is whether the fact that you signed the contract and chose not to read the terms, whether that makes any difference in terms of the obligation of the claimant. Did the claimant have any obligation at all, bar presenting this thing for signature? And you're saying they had no obligation, bar presenting the document. So your answer would be, even if it was buried in a thicket in complicated language which no one could easily understand, that would still be okay, would it? In terms of incorporation,
because it's a business. Because it's a business to business. I mean,
yes, business to business.
You see, that I think is the key point, though, is that this is a business to business contract where we really make a big difference. And the big difference is that we don't have requirements of transparency. We don't have requirements to of terms being able to be reviewed for fairness, so long as they're not core terms. All of those requirements don't exist because we're saying, well, business to business needs to be able to do what they want to do.
We do have some policing, but it's at a different stage of the analysis, as it were, because you accept that you have to accept, because it's statute. The Unfair Contract Terms Act gives a mechanism for challenging terms. Equally, misrepresentation gives the ability to challenge the whole damn thing. And separately, the idea of penalty. You can't get out of that either, because that's an aspect of public policy. So all you're saying is that those would be your only line of arguments. That is the Unfair Contract Terms Act, if it applies to the particular contract, and separately public policy and this idea of penalty. I think that's probably the point of difference between us at the moment. And I think Severine is nearer to me, are you not, than I don't know, maybe he's persuaded you down his road, as it were. But I think
there was enough nodding of the head that I think Severine has completely come over to my side.
The nodding of the head was with Maggie.
I don't mind being isolated. I don't mind being isolated on my own.
Do you know who's not isolated on their own?
That'll be Newcastle Law School and their LLM.
Excellent, we're getting there.
See,
we're getting there.
I have learnt something.
Newcastle Law School is now offering a brand new LLM in emerging technologies and the law. Find out how law, economics, politics and society intersect in a digital world. Visit ncl.ac.uk to find out more. And thank you, Newcastle Law School, for sponsoring Unpacking Contract Law.
On that interlude, I've got two quite interesting facts. I don't know if you picked this up. Did you see in this case that the judge refers to Good Life Foods and Hall Fire Protection?
Yes.
Which is one of the cases that talk about Interphoto. A small, vaguely interesting and not terribly relevant legal bit of information that I noticed is that the judge here in Blu-Sky sat in first instance in the Good Life Foods Limited case.
Yes, I'm so glad I wasn't the only one who picked that up. That's a little beautiful self-referencing. Isn't that what you're meant to do in every textbook?
Well, obviously,
Severine, do you do that on
you can remember that case. That's fair enough, isn't it? All right, I'll try you with another, I think, more interesting little fact. I know you're very keen on Lestrange and Graucob, Tim, because actually you are the big hero of that case, I think. If you look at that, you will see that Lord Denning was counsel, I think, for the cigarette machine that didn't work very well or at all. Because if you look at it, representation, it says A.T. Denning, which is, I think, Alfred Thompson Denning. So
I did not know that. I did not pick that up.
He became known as Tom Denning, but his first name was really Alfred, I think. And this is 1934, and I think he became a judge within about 3 or 4 years of that case, actually. But there he was arguing, just as you are arguing, Tim, my love. So there you are. You're in excellent company. I would say, as at 1934. With
sometimes I feel like that
Lord
age,
Denning.
Yeah.
So there you are. That's a
well,
blast.
I'm in good company. I will take that. I will take that
Be,
any day of the week.
Usually in great company if you're in the same mind as Lord Denning, for heaven's sake.
I mean, except of course he was paid for that quite handsomely to be in that camp, rather than. I mean, that's.
We have to agree and disagree, I think, on this one, because I think you would see the power of the signature as being game over, and I'm uneasy with that.
Would we still think this if we had, say, two large commercial players, say an accountancy firm and a law firm or something like that, battling it out over their terms and conditions, and the same happened? I don't think we would. I'm not saying that
But you see, the difference is that they didn't battle it out. When the defendant signed the order form, they didn't try to tell, no, we want our terms and conditions to prevail. So for me, that is, if the scenario that you are putting forward is, a battle of the form, that would be different. But here it was just they hadn't understood. Indeed, I mean, you're right, Tim. I would agree that ultimately, it is a case.
Shouldn't have spent £180,000.
Should we have signed that? Should we have not read that? But ultimately, for me, it's still the fact that incorporation and adequacy of notice, and the discrepancy that was untangled from whether the position of Bates or the position of Dubai needs to be untangled. For me, that is the interesting point, and so maybe they could have gone even further. So for me, that's why they got it right. They are hinting at the fact that so clearly it is now clear that, if there is a signed contract, if there is no signed contract. So for me here, that's why it is the right decision. There was no adequacy, or
I think that could well be one of the issues here. Lead. And I do wonder whether really at the heart of it, the problem is that these terms were on the website.
Yes,
right,
I mean, that's the point that makes perhaps your argument on this particular case not that strong in a sense, because the term didn't appear like the contract that Mrs. Lestrange signed. It didn't appear in the order form itself. It's a step removed from
I think
that.
Maggie, you glitched out in that moment where I was saying that those two cases, I think we do need to distinguish the case of here's the contractual document, right, sit down and read it and sign it, and there's all the terms in it, versus I'm making a reference to a website somewhere that the terms and conditions are on, now sign the document that makes reference to it.
Well, this is only the point that the judge made about this false binary.
But I don't think there is a false binary. I think they are.
Well, in some instances that it might be quite different, but it's so fact sensitive that I think that's what they're saying too. It would be very difficult to say in every single case these are different in nature, because of the variety in ways in which people will craft their paperwork.
Yes.
So we can't, I said the phrase before, we never say never, as it were. It just makes it much harder, I think, if you were the defendant here, to argue that insufficient had been given if the term had appeared on that piece of paper, the order form, that was signed. And the fact that they didn't realise what they were signing is really not really relevant for that point, as it were.
Although the not really realising, I think, is, if we look at the case, just as an outsider, and we look at this case, the real issue was that they had no clue and probably were, as close as we can get, misled that this wasn't a contract. And I think really that's where the law needed to act. This was not a problem of the terms being onerous as such. I really don't think that was actually at the heart of the problem, although that's the only way the judge could find the answer that they wanted to get to.
Well, they were onerous because, it was found to be onerous because when they looked at the figures, it was something like 8 times the actual administrative
but that's a penalty then
of cancelling. Well, that would be a different
exactly
argument.
that's
is that well, we didn't get that far. That's why I say that's a different argument. So we can't say for certain, but quite likely, yes, they would have succeeded on the penalty point, but they didn't need to go that far. But the 8 times the amount, and was there to frighten, I think that's the phrase that is used, there to frighten someone not to cancel, probably meant that this was a penalty, but we can only say probably because no one actually went that far. It was not necessary to go that far in the argument.
All these were obiter.
But also, they didn't actually define the legitimate interest properly, I don't think. I mean, that could have been...
It didn't need
fully engaged with.
Yeah.
It wasn't necessary to make life even more complex.
This was not a particularly good judgment, if I may say.
Well, that's a bit harsh. That's a bit harsh.
Okay, how can I water that down? How can I say that? I've said it now, hasn't it? It's recorded.
Judge Davies will not be listening anymore.
Yeah, that's it. Yeah, exactly. I think Judge Davies had better things to do than
well,
to listen to
I
our
would defend
podcast.
him. I thought he did that pretty well. I don't know what Severine thinks.
I would agree with this. I mean, it for me, when he starts by saying that he's got sympathy but it has no impact, I mean, it was said that the CEO didn't quite understand what she was doing when she of the effect of signing the form, and yet afterwards, so there is that should have no impact. So I think in a way that was a he tried to use the law to salvage the situation, but ultimately
But is it the sort of thing, I've never sat as a judge, but is it the sort of thing that a first instance judge would take care to say to remove a possible line of attack for an appeal, to make it clear that sympathies are not relevant here? You have my sympathy, but it's not relevant
legally,
to the decision.
I hadn't thought about it.
To avoid someone saying, as you are implying, it was from a sympathy judgment.
No, but in a way, that is a way that has no impact. But I'm going to try to find a way, and for me, that is a very persuasive judgment, because it is. The clause was onerous, and so yes, maybe there were, it is just a good thing that the clauses was not in the form, but for me that is the right decision and the right outcome.
Yeah, I think I agree.
I like the outcome, but I do not like how we got there. I think the abuse of this quite important, I think, device in business transactions. It's a really dangerous approach to start watering it down. The certainty that we had before.
You mean the power of the signature?
Yes.
You're talking about the power of the signature.
But as Legat said in Yamseng, there is a spectrum of commercial transactions, of B2B transactions.
Yeah, I agree.
Wow.
And you can see here that the term wasn't in the document signed. And can we not convince you that far, Tim?
Yes,
that is a bit different.
The fact that it is not in itself is an indication, and nor did they try to get, to explain. I mean, the liability of not contracting was quite drastic.
You mean the cancellation?
The cancellation, sorry, yes.
Yeah.
If we can ignore the obiter statement that this might happen, this should have the same effect if it were in the actual signed document, then I might be closer to being convinced that this might be a good decision. But that statement is pushing it way too far, I think. I do think there is a need for a regime for... which we had before and which we lost in the Consumer Rights Act, for businesses that are clearly out of proportion. If we look at this one, a care provider, this was being run by a couple of people, who didn't read the terms and conditions, who didn't even know this was a contract. These were not hard-nosed business people. The could be or should be a regime for, and I think this has been advocated by many others, for SMEs. Right, small, medium-sized enterprises. They need a separate regime to, the large accountancy firms, the large firms that we see nowadays that have, millions to throw out legal advice and so on and so forth, who need
but
the
in the absence of that, you would accept, wouldn't you, that the common law does its best to adjust to the variety of businesses that's out there. Can we put it thus?
Yes, but that could have been done differently here. We didn't have to erode one of such a fundamental misrepresentation. That would have been a great ground, if they could have found something there. We could have even stretched the idea of misrepresentation a little bit. I would have been happy with that. I just don't think that incorporation was the issue, even to the point that an argument that actually they thought they were signing something completely different and they had no idea. Fair enough, that would have worked for me. There was just no contract, rather than going down the incorporation route.
Yeah. So here they referred to the Dubai case where they say the signature, if they sign the contract, it's only invalid in the most extreme circumstances or unusual.
Yeah, but what do they mean by that?
Well, yeah,
what's extreme?
Because this doesn't sound extreme to me.
I know. So therefore, would we convince you that this, if the judge had gone down, no, that doesn't work because it was not there.
But you see, the most extreme, the most onerous terms are probably going to be penalty clauses. In which case, we have a device to deal with that. We don't need to erode the certainty of the signature.
Okay, but this is the sort of sliding scale, as it were, isn't it? There are terms that are unusual and excessive and exorbitant, and that may not be the same thing as a penalty. A penalty is possibly worse than that.
Mm-hmm.
Yes.
And given how small that little area of law is, this penalty idea, because you mentioned MacDessie case, that wasn't found to be a penalty.
No.
There was a legitimate interest, right?
Yeah, okay. So it's going to be even harder to get through the gateway, as it were, that's labelled penalty than it is to get through the gateway that's labelled unusual and excessive. What I'm trying to say is it's a sliding scale, and these are different things, and so therefore the argument is different.
I don't think you're going to convince me on this one.
But the trouble with Dubai, as Severine says, Dubai 925 and NatWest, if anyone's wondering what case that is, when it talks about only in extreme cases will it be possible to say that the document signed does not incorporate the terms whether read or not. But what the heck do you mean by extreme cases? Yes, okay, misrepresentation, but as Tim would say, but we've got another branch of law that can tackle that anyway, so it's probably not that. So what are we talking about, therefore? We're possibly talking about what Lord Mance said in possibly one of the cases that you've mentioned. I think it was he that opined this idea of being put under extreme pressure to sign, sign here, you've got to sign now, the deal's done now, or it's not at all, that sort of thing. Is that what is meant by extreme cases? Is there nothing else that is meant by extreme cases? You talk about certainty and predictability, Tom, as being Tim, as being the sort of hallmark of the common law.
Tom now.
Getting on the mind now. Well, you're kindred spirits. Yeah. Anyway, well, what do you
from
mean
Denning
by
to Bingham?
Extreme? What do you mean by extreme circumstances? That's what's so difficult. That's you like certainty and predictability from the signature. So what do you mean by extreme cases?
I don't think I would have the extreme cases either.
So you don't like Dubai 925 Limited either?
No, not particularly. No, I think that was another watering down along the way. I think that's where it started, and we have to also accept.
Man, isn't he? I think what I take from this is that Tim Dodsworth wishes it was 1934.
Well, what a conclusion! Actually, I've just noticed that is definitely going in the text of.
Let us take the world back to 1934.
Oh, that. Well, you've just made it a lot easier to describe this podcast.
Yeah.
Yes. That was easy.
I don't think we're going to wear him down. I think we've done as much damage to Dr. Dodsworth as we possibly can in this one. I think even I am going to accept defeat on this one.
Wow! I think I should take that as some sort of win, although I've not convinced you.
I was going to say, we're still
in
in the majority. That's
Yeah,
it.
yeah, I suppose
You're a minority, out
Okay,
of 3.
so if this was the Court of Appeal, Severine, in Blue Sky Solutions and Be Caring Limited,
we are in the
then
majority, and
there you go.
But I do want to note that both Dubai and Blue Sky are both just High Court decisions.
Yeah.
Right? I mean, there
we
is
said
no,
that at the beginning.
there's
And
no
so it-
real
so-
evidence that this is going
Yeah.
to. This is
No.
actually,
And so
and
is
I think that
Bates.
would happen. I don't
Yes,
think
it's
the
all
Supreme
first
Court.
instance at the moment. You're quite right.
And I think that the principle is too important to be, knocked over by a little case like this.
Yeah,
but
right.
even
okay.
if this is just a High Court decision, we still have talked about it for over an hour. So yes, thank
There was
you,
certainly
Mr.
something there, isn't
Yeah,
there?
yeah.
Yeah,
and-
all good, clean fun.
If our listeners do have questions or suggestions for cases that we should listen to, do email us on unpacking.contract.law@gmail.com. We're happy to discuss cases that you think are interesting as well, not just that we think are interesting.
Okay. And with that, we're thanking the dear listener or listeners for their kind attention, and see you next time. Rather, they don't see us; they hear us next time, possibly.
No, we haven't got any video recordings yet.
Probably just as well.
I think yes. I think that'll just be a disappointment for everyone. Bye.
Bye.